Yes, Mr. Hay.
Thank you. My lords and my lady, I appear for the appellant. My learned friends, Mr. Salter, King Counsel, and Mr. Edwards appear for the respondents. This appeal concerns the proper interpretation of the release in a settlement deed. The parties disagreed before the judge about whether released claims in respect of payments known in these proceedings as the deleted payment and the August 2013 payment.
Yes.
That is important to the parties because the first and the third respondents have asserted claims in Saudi Arabia in 2019 against the first appellant, Dr. Al-Hezaimi, in respect of some of those payments.
Yes.
The respondents say that the deed has not released any of the claims in the 2019 Saudi proceedings, and they commenced these proceedings to obtain declaratory relief to that effect. The appellants, by contrast, originally said that claims in respect of the deleted payments and the August 2013 payment were released, although, as I will explain, our case has recently narrowed, and we now accept that claims for the August 2013 payment were not released.
Oh, that's new, is it?
That is new, my lord. Yes.
I didn't see that in the skeleton.
No, that's developed since the skeleton.
We have read the judgment and the skeletons and looked at the settlement deed with some care. So we do have a fair idea of what the appeal is about. Can I just check? I see there's a live note. Will we be getting the transcript at the end of it?
Absolutely, my lord.
Yes, it affects how detailed a note we take.
Yes.
Thank you very much. Yes.
In that case, the court will have probably appreciated then that there are sort of three schools of thought on the proper interpretation of the release in the settlement deed. First of all, there is the judge's interpretation that the settlement deed did not release claims that the deleted payments were loans made to Dr. Al-Hezaimi. And my learned friends support that interpretation, and we say it's wrong. The second school of thought is our interpretation. We say that on the proper interpretation of the deed, claims in respect of the deleted payments have been released. And then the third school of thought is
all claims in relation to deleted payments. Yes.
That's right, my lord, yes. And third, the respondent's interpretation, which is that the settlement deed did not release any claims in relation to the deleted payments, except for claims based on the allegation that the deleted payments had been advanced or applied to purchase the English properties, the subject matter of the main action. In my submissions today, I was proposing to deal with those three schools of thought in the following way.
Yes.
First, I was going to look at the critical provisions in the settlement deed and to explain why the judge's analysis was wrong. Second, I was then going to move on to develop orally the appellant's case on the correct interpretation of the settlement deed. And then third and finally, I was going to address the respondent's interpretation of the deed and to explain why the court should reject it.
Thank you.
Before addressing those points, just three brief introductory points to make. First, while the term deleted payments has been used throughout these proceedings, it's a term that we have always said is inapposite because it fails to capture the fact that claims to those payments were not simply deleted, but were actually withdrawn and abandoned by the respondents.
I haven't understood that point. You'll have to explain that point in due course.
Yes.
But as I understand the facts, they were pleaded in the particulars of claim. They were struck through, apart from one which seems to have been overlooked and just omitted in the amended particulars of claim, and that's that. What is the significance by saying they've been abandoned? Then they've been taken out of the proceedings. There's been no admission that there is no claim at all in relation to them, has there?
Well, my lord, we say that it's relevant that they have been abandoned rather than just removed. Especially
it's that that I have difficulty with. What is the difference between removing something and abandoning it?
Well, my lord, we say it's relevant by way of factual matrix. We say that when one looks at...
No, you don't understand me. Semantically, what do you mean by saying they've been abandoned rather than removed? They've been deleted from the pleading. What is the difference between saying they've been removed from the pleading or removed from the case and they've been abandoned? I don't understand what the difference. What you mean by saying that's a different thing?
Yes, my lord. Well, I suppose we go further than just them having been removed. We would say removed means they have been taken out of the proceedings, but a right has been reserved to pursue them in other proceedings potentially.
Well, nothing was expressly reserved, but nothing was expressly ruled out.
That's true, my lord, in terms of how they were deleted from the particulars of claim, but we then say that there is more relevant factual matrix. We say we, in our pleadings, indicated they had been abandoned, by which I mean not just removed, but any claim in respect of them given up, we say. And that is then relevant when one comes to construe the settlement deed.
And if you discontinue proceedings, so in other words, if you issue a claim form, serve it, and then discontinue, what's the status of the claims that are made in that situation? Nothing more is said. I mean, you're entitled to put them into a new set of proceedings, aren't you?
Yes, my lord. We would accept that.
You don't, quote, abandon claims in that scenario.
No, that's...
So
right.
why do you say that doing what was done in this case amounts to abandonment rather than just simply removing them from proceedings?
Because, my lord, we say that what happened was, the claims were originally in the original particular claim. We served our evidence in our pleading which explained, we say conclusively, why there were never any claims in relation to those payments, because they were properly payments made for the UIMP business. We indicated in our pleadings that, the particulars of claim were then amended, those claims removed. We then pleaded back saying these claims have been abandoned, and in our submissions we said they were abandoned, and we were relying, in my submission when we said that, on the fact that we had produced evidence and explained what they were really for, and nobody had contradicted that.
Well, you say nobody had contradicted that. That's just not the case. Mr. bin Obaid served an affidavit in October 2017 in answer to your affidavit of 22nd September 2017, in which he said in terms, everything that Dr. Al-Hezaimi says is untrue. I mean, it's just nonsense to say that it hadn't been, it had been accepted. The fact is, nobody ever resolved what the payments were for because the disputes were settled. But I do object to the suggestion that in some way you can persuade us that Mr. bin Obaid had accepted that the deleted payments were for the UIMP business. That's just plainly contrary to his evidence, isn't it?
Yes, my lord. Well, I see the force of what your lordship says. I suppose just in terms of explaining the argument that we're putting to the court, it is that there's abandonment is more than removed.
I'm not sure this is really an important point. But I don't want to take up time with something that may be of no significance. But I just have difficulty with the notion that what happened was something more than just removing them from these proceedings, those claims.
Yes, my lord. And it may then be that my lord, that you have very little time for our first reason then as to why we say the deleted payments have been released, because obviously that is predicated on this argument that the deleted payments were in dispute, and we say that they were abandoned, and that's relevant when one comes to interpret the release. I see the force of your lordship's point that, well, all that's happened is these things have been removed, but nobody has said anything about them, and so one doesn't then know.
Well, people have said lots of things about them, but nothing was ever resolved about them. Anyway, as I say, I don't want to take up too much time with points that don't seem to me to be central, but if you think it's an important point, then obviously you must develop it.
Yes, my lord. Well, I'll come back to it when I speak about reason one, but I perhaps trail it now. The court will have seen that we advanced 4 reasons why we said. The 4th reason is another point that has now fallen by the wayside. So we're not going to rely on reason 4, and we're not going to advance that before your lordships. And that was a point which squarely put in issue, inviting your lordships to decide what the deleted payments were for. That's not a point that we're going to pursue now. So what we're relying on now are reasons 1 to 3.
Yes.
We're not relying on reason 4. We're not disputing that the August 2013 payment was released.
Thank you.
So, just to finish the 2 final introductory points that I was making, the second introductory point is just that when discussing the main action, I propose, as we did in our appeal skeleton, to refer to the appellants as the defendants and the respondents as the claimants. That makes it clearer. And the final introductory point is just to say there's no significant dispute between the parties about the law. The judge rightly said at paragraph 33 of the judgment that the usual principles of contractual interpretation apply, and nobody dissents from that. There's one small dispute about the significance of the concept of a general release in the context of settlement agreements, and I'll come back to deal with that in my submissions on our interpretation of the deed.
Thank you.
So I was going to then move to the first main topic, the settlement deed and the judge's interpretation of it. In light of my Lord's indication that the court's already looked at the settlement deed, it may be that your Lordships don't want me to take you through it again, but I'm happy to do whatever assists the court most.
I think you should refer us to those bits which you say are of assistance with the interpretation. I think it's not in dispute that what ultimately has to be construed is the words in the middle of a definition of claim, arising out of or in connection with the English proceedings.
That's right.
But if there are other bits which are helpful, then
Yes,
then you should show us which bits you say are helpful.
Yes, absolutely, my Lord. Well, in that case, I won't then take the court through just the structure of the settlement deed and to show you the definition of claims in that case, because that's well in the court's mind. The only thing in that case, he says, I don't know if it assists, but we've brought along just spare copies of page 129 of the bundle. That's of the core bundle. That's the page which has the definition of claims on it. I didn't know if that was helpful to have as a separate piece of paper. So
For my part, I'm happy with one version of
right,
it.
and
I don't know if my
that's
Lord
fine.
and my Lady would like a second.
I'd already provided myself with a second sort of exactly the page. But,
Right, okay. Then
I think we're fine. Thank you very
Okay.
much.
but if we're looking at the document, I would certainly benefit from at some point also having attention paid to the schedules or the annex, the schedule, and the claims that are now made or sought to be made, so that I can tie factually. So I'm clear about the factual overlap, if any.
Yes. Well, I'll come to look at the annex when I discuss why the judge was wrong. So maybe in that case, my lords, we can just move, I think, straight to looking at the judge's analysis then, and I'll pick up the relevant bits of the deed as we go through that. So the judgment is in the core bundle at tab 5, and the judge's analysis begins at paragraph 37, which is at page 53. And what I was proposing to do was to show the court the judge's reasoning and identify at a high level what we agree and disagree with, before then going on to explain in more detail the points where we respectfully submit the judge was wrong.
Yes, thank you.
So, starting in paragraph 37, the judge agrees the primary question is what the meaning of the words in the definition of claim are, and we don't dissent from that. The judge then agrees with our submission that the recitals of the deed do not assist in its interpretation, and we say the judge was right to accept our submissions about that, and we adopt the reasoning in paragraph 37 of the judgment. My learned friends still say against me that the recitals are of some assistance, but as I say, we say for the reasons in paragraph 37, the recitals of the deed don't help with understanding the scope of the relief.
Well, the recitals, when you read the deed, you start at the beginning with the parties and the date, and the first thing you come to is the background. It tells you, I mean, as recitals usually do, what the general purpose of a deed is. And for my part, I think the judge was a bit dismissive of the idea that the recitals were of any help. I think they do tell you, in very general terms, what the parties are trying to do. They're trying to resolve the disputes, and it's those disputes, and the disputes are disputes as to the in relation to beneficial ownership of the real property and money identified as described as the identified assets. That's what the parties are trying to do. Now, it's perfectly true that they're resolved on the terms of this deed, so you ultimately have to look at the terms of a deed, but was the judge right to simply say they were of no assistance or little assistance? I would have thought it was a good place to start if you're trying to work out what the parties are trying to do.
Well, I mean, yes, I mean, we accept that for the they provide assistance in terms of the general background of what the deed is trying to do, but in terms of the specific question of what is the scope of the release, we say they provide little assistance, because all they indicate is that they're resolving the disputes in the main action on the terms of the deed. But then that doesn't tell one, well, does that mean that they're resolving the disputes by also releasing the deleted payments? Because we say, for example, that was important to us. And ultimately, there's just nothing in the recitals we say that really helps with answering that question.
Okay, well, let me put this to you, and don't deal with it now. If it naturally comes later, the English proceedings are premised on an assertion that there was an oral agreement between the parties under which the claimant would provide funds, the defendant would buy property, and it be held for the claimant. Now, all of that was in dispute, but the thrust of the English proceedings is a claim to the beneficial ownership of English real property and some cash which is not really explained in the papers before us, but I assume is derived in one way or another from that property. Now, that seems to me to be a very different type of dispute from, I have had business dealings with you in Saudi Arabia and Egypt and maybe elsewhere, and there are all sorts of issues, and maybe all sorts of issues around that. Now, it is obviously possible in settling a claim in relation to beneficial ownership of English assets to settle anything else you want to. But I think one would start with an assumption that what the English proceedings, and hence what the settlement deed was focused on, was that claim to beneficial ownership of English assets, which after all is why the claim was brought in England. And that if it goes much wider into the parties' general commercial relationship, it was intended to do that. It's slightly surprising that there's no reference to that anywhere.
Yes, my lord. Well, I think I will deal with that in greater detail when we look at reasons 2 and 3.
Yes.
Our answer to that, though in brief, is what the deed released was the any claims arising out of the issues that were disputed in the main action. And so one has to look at more than just what was being claimed in the main action, what the claimants were saying, particular payments have been made for, but what in totality the parties were arguing about in that action.
Yes, okay, I see.
And so, my lord, we, again, just in high level, we say that deleted payments were in issue in the main action at the time the deed was entered into for 2 reasons. One, which is what I've called reason 2, there was the set-aside application.
Yes,
the deleted payments.
Yes, I understand that, yes.
And the third point, reason 3, second point, is that the deleted payments were important background to understanding what the actual payments that were being claimed in the main action were. To understand what those payments were, or the purpose of those payments were, one had to engage with what the purpose of the deleted payments were, because that all formed one piece. And it's probably easier if I explain that by reference to the documents in the main action when we come to it.
Sorry, just to pick you up, and
yes.
I don't want to start construing your submissions as a statute. I'm not trying to do that, but I thought the point was that, as the recital indicated, what's actually in dispute in the main action is who owns properties and who owns monies, which are in England. I mean, that's ultimately, isn't it? I mean, for example, if we haven't looked at the pleadings, but if you were to just look at the recital as a summary of what the parties thought they were being in dispute about, they had been in dispute about the beneficial ownership of real property and money described as the identified assets. It's an ownership dispute, for want of a better expression, according to the recital.
Yes, my lord, I suppose it's a very high-level summary. Yes, I would accept that's right. But when there's in terms of the dispute about the money that had been paid, that does engage a wider compass than just looking at the English properties, because of course it was my client's case. Well, these monies had been paid to me primarily for the UIMP business, for use in the UINP business, but also for some other purposes associated with our business dealings together. And he was, in his defence, advancing that positive case as to, no, this is what these payments were for. And that's why we say that when one looks at the scope of the release and the deed, it's important to ask what the issues in dispute were. Because we say it would be an odd result if we had to re-argue that point again. Because now in Saudi Arabia, claims are being subject to the deleted payments. They're being said to be loans. And we are again saying, no, they're not loans. They are payments that were made to us for UINP business or other parts of our business dealing. So we're running effectively again the same positive case that we were in the main action.
So you say the recital needs to be read with the understanding that, in a sense, it's written from the perspective of the claimant who's saying, that the properties and money in England are owned beneficially by me because they were bought with my money. And the defendant says, actually, no, the money that was paid became my money and the properties were mine.
That's right, my lord, yes.
So you say it wrapped into the sort of ultimate beneficial ownership question, as here identified, are questions about what the payments were for.
That's right, my lord, yes. I mean, we would just say paragraph 1 is a very high-level summary of really the claim that was being asserted against us. It doesn't, for example, deal with our counterclaim.
Right.
We had a counterclaim.
And then the second question, coming from the recitals, is it focuses on the identified assets, which picks up a point I made a few minutes ago. The identified assets are the ones listed in the schedule.
That's right, my lord, yes.
And to what extent, if at all, are they connected, are those assets factually connected with the deleted payments?
Well, they are not connected factually. The properties themselves are not connected directly to the deleted payments at all.
I mean, that's why they're deleted payments.
Exactly, that's right, my lord, yes.
Which is quite a significant point, isn't it?
Yes, but only if one is looking at what the claims in the main action were. We say when one looks at what the issues that were disputed in the main action were, then it becomes important for the purposes of my third reason to look at the deleted payments, because they provide important context to the payments in respect of which claims were being made. Because what we said in the main action was, I think it was common ground, this was a relationship where there were not a great deal of formal legal documents. There was not a great deal of formal correspondence. A lot of things had been dealt with orally. And so in resolving the dispute about what were the purpose of the payments still being claimed in the main action, we said it was important to look at the totality of the parties' relationship so that one could then see from that, one could then zoom in and look at particular payments. But it was important not to look at those in a vacuum. And we said that looking at the deleted payments was part of that wider exercise. And again, I'll come on to show how that was put in the main action, and therefore why we say the deleted payments were still in dispute, even though claims weren't being asserted in relation to them. So I think then coming back to the judgment, which is where we were, we had looked at paragraph 37. I was just trying to summarise sort of at a high level which bits we agree with and which bits we disagree with. At paragraph 38 of the judgment, the judge, this is page 53 of the core bundle, the judge begins by saying in the first sentence it's important to ask the right question, and we agree with that. She then said the questions are not whether the deleted payments arise out of or are connected with the main action. And again, we agree. If one is being precise about the language of the settlement deed, that is not what it requires one to look at. But we do, as I will explain, say that whether and how the deleted payments are connected with or arise out of the main action is important when one comes to consider the right question. The judge then, in the remainder of paragraph 38, noted that she agreed that the deleted payments were connected with the main action. We say the judge was right about that, and we'll come back to the significance of that when I addressed the court on our interpretation of the settlement deed. At paragraph 39 of the judgment, the judge identifies what she concluded was the right question to ask, namely whether any particular claim is a claim or cause of action arising out of or in connection with the main action. We say that is with one important clarification right, and I'll explain that clarification in just a moment. Then, at paragraph 40 of the judgment, the judge explained on her analysis what particular claims are claims or causes of action arising out of or in connection with the main action. And it's here we say the judge fell into error. We say the judge adopted too narrow a view of what particular claims fall within that test, and therefore gave the release in the deed too narrow a scope. That erroneous approach in turn led the judge into error in paragraphs 41 and 42 of the judgment, where she concluded that any claim to be repaid moneys lent was not one arising out of or in connection with the main action, and so concluded that claims to the deleted payments asserted on the basis that they were loans were not released by the deed. So with that very high-level overview of our position on the judge's analysis, can I turn to the detail of why we say the judge's approach was wrong? We've addressed that in paragraph 21 of the appeal skeleton, which is core bundle tab 15, page 177. The first and most important reason why we say the judge was wrong is that the judge's analysis is inconsistent with the ordinary and natural meaning of the words used in the definition of the term claim. We say that that is important because the deed was a formal document negotiated and prepared on both sides with the assistance of lawyers and concluded between sophisticated parties. In those circumstances, the natural meaning of the words used is of particular and principal importance. The term claims encompasses all and any claims or causes of action of any kind arising out of or in connection with the English proceedings. What does English proceedings mean? That's defined on page 129 of the court bundle, clause 1.1 of the settlement deed. What it means is the proceedings in the main action. It means the proceedings under claim number HC 2017-001893. So we say the focus is not on simply the claims or causes of action that were advanced in the main action at the time the settlement deed was concluded. The language is wider. It extends to the proceedings as a whole in the main action. And when one asks what did the proceedings comprise, it's necessary to identify not just what claims were advanced, but also what defences were raised, the responses to those defences, and the other applications or matters in dispute, so that one can identify in totality what the issues in the proceedings were. We therefore say that on the natural meaning of the words used in the settlement deed, the critical question to ask when deciding what claims or causes of action were released is, was a given claim or cause of action one which arises out of or is in connection with the issues that were disputed in the main action? And in my submission, the judge did not correctly apply that test. So if we pick up the judgment again at paragraph 39, as I said, we agree with the first sentence. The right question is not simply, do the deleted payments arise out of the main action or are they connected with it? We then agree with one clarification with the second sentence. As I've identified, we say the key question is whether a given claim or cause of action is one which arises out of or in connection with the issues that were disputed in the main action. And it's not entirely clear to what extent the judge disagreed that was the right question. The judge defines the term the main action at paragraph 5 of the judgment, which is core bundle tab 5, page 38. And she defined that term as the set of proceedings commenced by the claimants against the defendants in this jurisdiction in 2017 under claim number HC 2017-001893. So if one plugs that definition into paragraph 39, the test which the judge adopted is whether any particular claim is a claim or cause of action arising out of or in connection with the set of proceedings commenced by the claimants against the defendants in this jurisdiction in 2017 under claim number H7 2017, blah, blah, blah. The judge therefore recognised here that the question is whether a particular claim or cause of action arises out of or in connection with the main action proceedings generally, and not just, for instance, the claims pleaded in the main action. And if that was the test the judge endorsed, then there is little between her and us. And we then agree with the final sentence of paragraph 39.
So, just to try and encapsulate that in a sentence or so,
yes.
I mean, it's, you say when it says arising out of in connection with the English proceedings, you interpose the words with any issues in dispute in the English proceedings.
Yes, the issues that were disputed in the proceedings.
Or indeed any issues in dispute in the English proceedings, to include issues on the pleadings, but also issues, factual issues, which go, for example, to the set-aside application.
That's right.
And is this right? You say that the brackets that follow, the parentheses that follow the words English proceedings, including for the avoidance of doubt any counterclaims, well, you'd say yes, and any orders for payment of costs, which are not really issues as such, but give an indication that you must read the English proceeding wider. Is that right?
Yeah, yes, that's right.
Because on any view, an order for payment of costs is not really an issue in the proceedings. It's just it's an order that's been made by the court.
Yes.
So you say that gives the indication that the English proceedings is wider than simply a claim made on the pleadings in the English proceedings.
Yes, but that's what we say, my lady. That's what we say about paragraph 39 of the judgment. Paragraph 40 of the judgment is where we say the judge fell into error, and that is because either the judge had in mind the wrong test or did not correctly apply the right test. So instead of asking whether a given claim is one which arises out of or in connection with the issues that were disputed in the main action, the judge instead adopted a much narrower view of what would satisfy the definition of claim. We see in paragraph 40 she identified three groups of claims that would satisfy the test. First, the precise claims that were actually asserted in the main action at the time the deed was executed. Second, claims which depend for their existence on something done in the main action, such as a claim for costs, one example that the judge gave. Third, the precise claims which had been asserted in the main action but that were abandoned or removed. So the claim the deleted payments were for the purpose of investment in property in England were satisfied, said the judge. So pausing there, insofar as the judge was suggesting that these are the only three groups of claim which could satisfy the definition of claims in the deed, we say that was wrong.
What's the judge's reason for the view expressed in the last sentence of paragraph 40? I mean, I can see that she takes the view that, but why? It seems to be dealing with a different issue. Different species of thing, or it's a different question that arises. Has she previously given any clue as to why she takes that view?
No, she hasn't, my lord. I think really from paragraph 37, which we've looked at, that's really the start of the reasoning. I assume the judge takes that view because since that specific claim had been in the proceedings, that was sufficient to, even though it had then been removed, that was sufficient to make it one which would arise out of those proceedings.
But you previously identified you previously, I think, accepted that the identified assets as defined are not assets which are linked in any way to the deleted payments.
Well, they're linked, as I say, in that broad sense that in order to work out what the purpose of the payments that gives rise to the identified assets, they're relevant. But yes, I accept that the deleted payments are not payments which were for the properties that made up the identified assets.
Does the judge deal with that disconnect anyway?
Well, we're coming on in paragraph 41 to deal with specifically, a bit more focus on why she says that the deleted payments were not released. But no, my lord, I don't think she does deal more specifically with it than there. So the submission that I was making was that insofar as the judge was suggesting that the three groups of claim in paragraph 40 are the only things that would satisfy, they're the only groups that would satisfy the definition of claims, we say that was wrong.
She doesn't expressly say it's limited to those.
No, I recognise that, my lord. It's not entirely clear whether she was just giving examples, in which case then we have no problems with those as examples, but obviously we say that there's more. Yes. Or if she's saying these are the categories, then, and that may then be her reasoning, because paragraph 41 arguably would follow from such an analysis, then of course we do disagree with that. It's probably helpful then for me just to say why we disagree with that, so your lords and my lady have it. We say that would be wrong for three reasons. The first reason is that to decide what issues were disputed in the main action, one has to look not just at what specific claims were or had been asserted, but what the issues that were in dispute in the proceedings were in general. Court has my submissions on that. That follows from the language of the deed. The second reason we say why that would be wrong is that the judge's analysis failed to give any real meaning to the words "in connection with." Those are broad words which extend the definition of claim from any claims or causes of action arising out of the main action to a wider group of causes of action which are simply connected with it. The three categories of claim which the judge recognised in paragraph 40 of the judgment are all, as she herself acknowledged, things which arise out of the main action. And we therefore say her approach gives no real meaning to the words "in connection." The third reason is that the judge's analysis is difficult to reconcile with clause 4.1.1 of the deed. Helpful if we look at that. That's on page 132 of the core bundle. This is the release provision, and it says 4.1, each of the parties agrees on behalf of themselves and their respective affiliates that this deed shall constitute full and final settlement of all claims against each of the other parties and their respective affiliates. So the definition of claims plainly encompasses claims against affiliates, because those claims are being released. But on the judge's approach, the release of claims against affiliates is reduced in practice to almost nothing. It would appear to consist only of claims against affiliates for something which was done in the main action, and it's difficult to see what claims those might in fact be. Moving on, coming back to the judgment, looking now at paragraph 41. The judge in the first sentence makes the general statement, but in my judgment, a claim to be repaid monies lent is not a claim which arises out of or in connection with the main action. Now that conclusion, as I said, may draw support from the reasoning in paragraph 40, because a claim to be repaid monies loan is not a claim falling into one of the three boxes of claims which the judge had identified in paragraph 40. And if that was the judge's analysis, then for the reasons I've just given, we say that's wrong. The judge then went on in paragraph 41 to say, the claims which were removed by amendment from the particulars of claim in the main action were claims that the deleted payments had been made to enable Dr. Al-Hezaimi to acquire English properties for the benefit of Mr. Abeid. It was those deleted claims which continued to feature in the evidence on the set-aside application and generally at the trial. Those claims were not claims that any of the deleted payments had been made by way of a loan to Dr. Al-Hezaimi. Claims based on the contention that a deleted payment had been made to Dr. Al-Hezaimi as a loan never formed a cause of action pleaded in the main action, did not feature in the evidence in the main action, and did not feature in the list of principal issues for the trial. Such a claim is not, in my view, connected with the main action, nor would it arise out of it. With respect, we say that reasoning is also wrong. It's wrong because the judge was focused on what claims were asserted in the main action. The judge concluded that because claims to the deleted payments were never asserted in the main action on the basis they were loans, such claims were not released. But that does not apply the right test. The right test is to ask whether a claim in respect of a deleted payment arises out of or is connected with issues that were disputed in the main action. That is a test which looks beyond simply how the claimants formulated their claim to the deleted payments, and instead looks to what the matters that were and had been in dispute concerning the deleted payments were, including the appellant's consistent contentions about the true purpose of those payments. If that broader correct test is applied, then, as I will explain when I address the appellant's case on the scope of the release, the correct conclusion is that claims in respect of deleted payments are ones connected with the main action. So those are the reasons.
If you read claim in the way that you suggested, namely that you insert the words "the issues" in the English proceedings or issues arising in the English proceedings, live issue, issues still at large, as it were, in the English proceedings more generally,
yes,
then in fact, if you say, well, one of those issues was for what purpose were the deleted payments made, or put a different way, who owned the monies paid by way of deleted payments, then falls, you'd say the allegation that those payments were made by way of a loan falls squarely within the same question. It's the same question.
yes, exactly, that's right, my lord. Yes, because I mean, our issue is when we come to commercial reasons, our point is that we have released. It's sensible that we have released claims in relation to the deleted payments because we shouldn't have to argue again about what the true purpose of those payments were. We have said that we were geared up to argue in the main action that they were purposes paid for the purpose of the UIMP business. And so whether we have to argue again that they were made by way of a loan or they were made for some other purpose, we would have to re-argue exactly the same positive case again, because we are always going to be saying, no, these deleted payments were made for the UIMP business.
Can I ask you to imagine that the set-aside application hadn't been made, and so that the issues arising in the set-aside action had not been in issue? In those circumstances, in what way would the purpose of the deleted payments have been a matter for trial? Because they weren't any longer on the pleadings, they'd been deleted. Why would it be significant to investigate, or would it be significant to investigate the purpose of the deleted payments at trial?
Yes, can I give a sort of abridged answer to that now, my lord?
And then deal with it.
Yes.
Yeah, you're going to come to it. It's your ground one, really, isn't it?
Yeah, it's my reason number 3. That's right, my lord.
Sorry, third reason.
Third reason, yes. But to give you an abridged answer, we say on the pleadings, the purpose of the deleted payments was still in issue. There were no claims to the deleted payments. What the purpose of those payments was still in issue.
Well, you pleaded it in your amended. You left it in your amended defence, and there's an answer in the reply. I saw that.
Yeah. So,
but I couldn't see what it went to. I couldn't see what issue it went to. Which of the actual issues which the trial was designed to resolve required, as I say, leaving aside the set aside, which I think is a different argument, But if one assumes that's not there, which of the issues on either side required resolution of why the deleted payments was made? I couldn't understand that.
Well, I will show you the submissions that we made in the main action as to why they were relevant. But in short, we say the issue that they were relevant to was what was the true purpose of the payments for which, in respect of which claims were asserted in the main action. Because we said that answering that question could not be done in a vacuum. One needed to look at the wider relationship between the parties. And part of that wider relationship was the deleted payments. And if one were to resolve what the true purpose of the deleted payments were, that would be relevant to the general framework of the parties' relationship and the credibility of the witnesses.
But I can't believe that simply because a point goes to a witness's credibility, that it, therefore, when you settle the action, you're settling every issue which could have gone to their credibility, because that could be their entire relationship with you. If that was what was intended, you'd expect a very different form of settlement.
Yes, and as I say, when we come to look at the submissions we were making in the main action, what I will submit to your lordship is that we were heavily relying on the purpose of the deleted payments. This was not just some peripheral issue in the background that went just to credibility. We had a number of stages stressed the importance of it. And so when one is looking at what the real issues that were in dispute in the main action were, we say that the purpose of the deleted payments forms part of that group. Okay. Now, I recognise, my lord, that there is then, that inevitably introduces something of a sliding scale, because of course your lordship can say to me, well, at one point Mr. Benedek was asked one question about something to do with his credibility. Does that mean that was an issue that was in dispute? And I would recognise that, being sensible, of course, the settlement agreement can't have such a broad scope. But we say, given the centrality of the deleted payments to our submissions, that it is probably regarded as an issue that was in dispute in the main action, and that's all relevant by way of factual background to interpreting the deed.
Okay, thank you.
Let's just quickly then on the remaining reasons why we say the judge's approach was wrong. I've addressed the court on why we say it was wrong as a matter of the ordinary and natural meaning of the words used. We say it was also wrong because the judge's approach produced strange and unlikely results, which are unreasonable and inconsistent with business common sense. We've dealt with that in paragraph 21, 2 of our skeleton, and I won't develop that orally. The third reason why we say the judge's analysis was wrong is that it ignores the permissible factual background against which the settlement deed was concluded. We've explained that in paragraph 21, subparagraph 3 of our skeleton. In short, we say the main action had culminated in a costly and significant trial, which was estimated to last 3 to 4 weeks. That estimate reflected the wide-ranging factual matters in dispute. They included disputes about the nature of the parties' dealings and commercial relationship and the purpose for which particular payments were made, all of which required an analysis of extensive and largely informal communication by WhatsApp or phone over a significant period of time. We say it's improbable that the settlement deed, which was concluded to bring the main action to an end, did not settle all of the issues that were disputed in those proceedings, including the purpose for which the payments in dispute were made. The fourth reason why we say the judge's analysis is wrong is that it's inconsistent with the purpose of the settlement deed. We say the purpose of clause 4 of the settlement deed was to be a general release of the issues that were disputed in the main action. We say that is apparent from the language the deed contains, in particular the wide definition of claim, which we've looked at and which releases all and any claims or causes of action of any kind in any jurisdiction, whether under English or foreign law, whether civil or criminal in nature, and whether they are arising out of or are more broadly in connection with the main action.
Yeah, I mean, what that definition doesn't do is include the words issues in the English proceedings, which you've suggested it means. And although I can see why you would potentially place reliance on the words in parentheses. There is a second for the avoidance of doubt provision at the end of it, which again talks about claims in the English proceedings rather than issues in the English proceedings, so that the at some point I'd be assisted by your analysis of that last bit as well.
Absolutely. Well, that sentence is relied on against me by my learned friends, and I was proposing to deal with that in the third part of my submissions, where I deal with their interpretation of the deed.
Yep.
But yes, I will come to that. So while we say the language of the definition of the term claim makes that purpose that it's a general release of the issues in dispute in the main action, but we say clear. We also draw support from a general observation made in the speech of Lord Nichols in BCCI and Ali. I don't propose we turn that up. Your Lordships will find that in the authorities bundle tab 2. We've marked up the. Maybe it is helpful if we just look at that. It's in authorities bundle tab 2, and the speech of Lord Nichols begins at page 36 of the authorities bundle. It's page 264 of the report. Just by way of background, in BCCI, some employees of the claimant bank, including Mr. Naeem, were made redundant. In return for payments from the bank, the employees signed an agreement in which they accepted the full and final settlement of all or any claims of whatsoever nature that exist or may exist against the bank. The issue which arose was whether that language released claims of the employees against the bank for stigma damages, which the employees were not aware and could not have been aware of at the time the agreement was executed. Now, we're not concerned in this case with the question of whether unforeseeable claims have been settled or not, but we do say Lord Nichols' observations at paragraph 22 and 23 are of assistance. What he said was, my lords, this appeal raises a question of interpretation of a general release. By a general release, I mean an agreement containing widely drawn general words releasing all claims one party may have against the other. The release given by Mr. Naeem was of this character. Mr. Naeem accepted a payment from BCCI in full and final settlement of all or any claims of whatsoever nature that exist or may exist. The circumstances in which this general release was given are typical. General releases are often entered into when parties are settling a dispute which has arisen between them, or when a relationship between them, such as employment or partnership, has come to an end. They want to wipe the slate clean. Now, applying those observations to this case, we of course accept that the settlement deed is not as wide as the general release.
I have to say, I don't find this of any help at all. I mean, what Lord Nichols is dealing with is a general release, which is when a relationship, in that case of employment, comes to an end, and the parties are going to walk away and hopefully have nothing more to do with each other ever again. And it's in that sense they want to wipe the slate clean, and the words are entirely general. It's obviously a difficult question which the House of Lords was split on as to whether that included things which you didn't know about. But that's not the problem we're faced with at all. We know this is not a general release in that sense because we know it's limited to claims arising out of or in connection with English proceedings, and there's a for the avoidance of doubt clause which makes it clear that the parties contemplated that they could and would continue to litigate other disputes. So the question is the ambit of the release, and it's obviously not an entirely general release. So I don't find, with respect, the statement that's intended to wipe the slate clean as of any assistance at all. Of course, if a dispute is settled, it's settled. But the question is, how wide is the settlement?
Yes,
so what assistance do we get from this?
My Lord, we say that the point that I was making about the purpose of the settlement deed is spelled out from the words of the settlement deed, but we say this corroborates the purpose that I was indicating, which is we say that the purpose of the settlement deed was to wipe the slate clean between the parties so far as the main action was concerned. I of course
yes, and that I think is not in dispute. And the question is, how far does it go?
Yes. Well, then, my Lord, then I don't think I can take that point very much further then in that case. That then leaves me just the fifth and final reason why we say the judge's analysis is wrong. And we say it's wrong because it's inconsistent with other provisions of the settlement deed. We've dealt with that in paragraph 21, subparagraph 5 of our skeleton. In short, the settlement deed divided a pool of assets defined as the identified assets between the claimants and the defendants. And we can see in clause 3.2 of the settlement deed, which is in the core bundle, page 130. We can see clause 3.2 that the parties agreed that in the 14 days following the execution of the settlement deed, they would use their best endeavours to agree an appropriate mechanism to transfer the identified assets to reflect their agreement in the deed about who would own what. Clause 3.3 then set out...
Just pausing there.
Yes.
The deleted payments have nothing to do with, I think you accept, the identified assets which need to be divided up.
That's right. They don't form, the deleted payments don't form part of the identified assets. So in terms of what is being split, nothing is being said, well, this deleted payment for £100, you get that. I accept that that isn't.
And it's not suggested that the cash balances, which are all listed on page 139 and which are split on page 138, have anything to do with deleted payments. So they're rental, proceeds of sale of flats, other bits of cash from the payments which are in issue.
That's right. I think that they may also have been some of the cash that was left, that may have been left over. I think it's right that Mr. Binobey transferred various amounts of money to my clients. I think it may be that not all of that money was applied to the property. So yes, there was some suggestion that maybe some of it had been left over. If that's right, then that would also, I think, fall within the identified assets, but I would just have to double check whether that's right. But otherwise, yes, you're right, my lord, it's that kind of cash.
Yeah.
So clause 3.3 then set out the fallback mechanism that would apply if, in effect, no better agreement was reached in 14 days as envisaged by clause 3.2. The mechanism in clause 3.3 included subparagraph H, which is over the page 132, an obligation to promptly sign the discontinuance order and the release order. We can see the release order at Schedule 4 to the deed. That's on page 148 of the bundle.
Yep.
And what this deed did was to release the parties from various undertakings which they had given to each other.
Yes.
And operative, paragraph 6 on page 149, we can see that the claimants were released from the claimant's undertakings. And those were undertakings given in the freezing order that had been obtained, and in a further order that was consequent upon it. And in paragraph 7, we can see the claimant solicitors are released from their undertakings, and the fortification fund shall be repaid. The fortification fund was a fund of $500,000 created to support the undertakings given by the claimant in the freezing order. And finally, in paragraph 10, we see that there will be no order as to costs.
Yes.
And for completeness, there is an identical provision in paragraph 4 of the discontinuance order, which is on page 147.
I haven't quite understood why, having gone to the trouble of settling it in the Tomlin form, which enables you to bring an action without starting a new action, you then slightly later discontinue the action, which means you can't. Was there any particular reason for that?
I'm afraid I'm not able to help my lord with that. So we say the effect of the release order would therefore have been to release the claimants from any liability under the undertakings they've given.
Yes.
To support the freezing order. It either on its own or when taken with the discontinuance order also release them from any liability for costs in relation to the freezing order, which obviously included our costs of the set-aside application.
Yes.
And as we will see in a moment, the true purpose of the deleted payments were an integral part of the set-aside application. So we say the judge's analysis is inconsistent with that contractual context. The result of the judge's analysis is that although the defendants have given up their entitlement to costs consequent on succeeding on the set-aside application, as well as any claim under the undertakings, the claimants are still free to assert claims in respect of the deleted payments, provided they aren't precisely the same as those which at one time formed part of the main action. What that in practice means is that the defendants could be forced to argue all over again about the true purpose of the deleted payments. They would have to re-argue the issues which underlay the set-aside application. And in my submission, there would be an uncommercial and unreasonable mismatch if the defendants have given up their costs of the set-aside application and any claim under the undertakings, but the claimants have not correspondingly given up claims in respect of the deleted payments, so that the defendants would have to incur again the costs of proving the true purpose of the deleted payments. So
I haven't quite understood why those are inconsistent. I mean, I don't find it at all surprising, but if you're settling an action and counterclaim, you settle it entirely, including cross-claims for costs on both sides, claims on cross-undertakings, release the fortified fund, and so on. All that seems to be naturally follow from settling the dispute which is in the English action, using very general words. I don't see why it's inconsistent with that to say that a dispute which is not, well, this is the question, which is not part of the English action should be able to be pursued in Saudi Arabia. I just don't see why it's inconsistent.
Well, because what the release order and to an extent the discontinuance order are targeted at includes the set-aside application.
That I understand. But
and part of the critical to the set-aside application is what were the true purpose of the deleted payments.
If we go back to a question my lord asked you earlier,
yes.
Think of a world in which the set-aside application hadn't been made.
Yes.
And the deleted payments have been taken out of the proceedings by amendment.
Yes.
And those proceedings are then discontinued. Nothing more is said or done. I think you accepted that it would be open to the claimant to bring proceedings in this jurisdiction in relation to the deleted payments.
Well, if I did accept, I didn't mean to. I think I was accepting in a general case.
Yeah, in a general case.
In a general case,
absent this agreement. Sorry.
Yes.
Absent this agreement, in those circumstances, the claimant could, without any restriction, sue for if he wanted to for repayment of the deleted payments. So you're saying the effect of this contract is to prevent that from occurring?
That's right. Yes, and that's because either reason one, it's significant that deleted payments had at one time been in dispute and we say had been abandoned, or reasons 2 and 3, they were actually still in dispute in the main action at the time the deed was executed.
I asked you to forget the
but yes,
put aside, set aside.
But even ignoring the set aside, reason 3 is the deleted payments were still in dispute as part of this wider investigation into what were the purpose of the payments that were claims were asserted in respect of, and we were submitting that one had to look at the relationship in the round, and the deleted payments were an important part of that exercise. But I accept, my lord, in an abstract case, if one had a claim to the deleted payments, they were removed. No set-aside application, no suggestion they were relevant to what was still being claimed in the main action, or at best were asserted peripherally as part of a challenge to credibility or something like that. Then I would accept a deed in these terms wouldn't release claims to those payments in that situation.
Yep.
Does that assist? So, my lord, that was everything that. My lady, that was everything that I wanted to say about why we say the judge's analysis was wrong. And if the court agrees with us about that, then it will be necessary to consider what the proper interpretation of the deed is. And that is the second topic of my submission. Just to reiterate something I said at the beginning, but just give all this down. We advance in writing 4 distinct reasons why we said the deleted payments are claims arising out of or in connection with the main action. They're summarised in paragraph 23, and just to confirm again, we continue to rely in full on reasons 1 to 3, but we don't rely on reason 4. Again, just to reiterate the concession, we are not, we now accept that the settlement deed did not produce claims for the August 2013 payment. So with that introduction, can I turn to look at the first reason why we say that claims in respect of deleted payments were released? That's dealt with in paragraph 24 onwards of the skeleton.
Yes.
Just to deal with that at a high level, in short, we say the starting point is the words of the settlement deed, the ordinary and natural meaning of the words used, release claims which arise out of or are in connection with the issues that were disputed in the main action. Applying that test to the facts, claims were asserted in respect of the deleted payments in the original particulars of claim. The defendants explained why those claims were hopeless on the facts, both in their defence and their evidence served in support of the set-aside application. The claims to the deleted payments were very shortly afterwards removed, or we say abandoned. They were never reasserted at any time before the conclusion of the settlement deed. Having originally formed an integral part of the main action and been abandoned because of pleas and evidence advanced in that action, we say that claims in respect of the deleted payments are at least in connection with the issues that were disputed in the main action.
Well, you said that they were abandoned because of your pleas and your evidence. I think Mr. Bin Obaid would say they were abandoned because, having looked with more care at what he could and couldn't identify as having been paid for investment in English property, and with the benefit of third-party disclosure, he decided that these payments were no longer ones he wanted to rely on. Doesn't necessarily mean he accepted your evidence. And as I said earlier, I think he was quite forthright in saying he didn't accept your evidence.
Yes, my lord.
I mean, it would be different if there was correspondence saying, in the light of your client's evidence, which we accept, we are not going to pursue these payments. Then I could see that there had been something you could point to as an acceptance that these payments were as you said them to be. But I didn't see, unless you can point me to it, anything in the material before us which suggested that Mr. Bin Obaid had ever accepted that the deleted payments were made for this reason or that reason or the other. All that he was accepting by his deletion was that he was not pursuing a claim that they'd been paid for investment in English property.
It's right. You're right to say that I can't point you to a letter like that. We say that we can surmount the threshold needed to show that these, to satisfy the test in the settlement deed with something slightly less than that. That's my submission to you. How we surmount it is because we say we put in our evidence which showed what the true purpose of them was. That evidence was not contradicted, and instead the claims were removed. At no point was it thereafter said to us, well, whoops, we accidentally asserted claims to payments that were in fact loans. Sorry about that. We're going to withdraw those claims, but so that anybody isn't confused, we do or we may have claims in respect to that. We say that they were just cleanly removed with no answer to our evidence. And in fact, as I will come on to show the court now, indeed by the time of the trial for Mrs. Justice Fold, as she then was, the claimant's own evidence was that 4 of the deleted payments had been made by Mr. Bin Obaid for purposes concerning the UIMP business. So we say not only were the claimants making no suggestion that they had claimed to deleted payments, but their own positive evidence from Mr. Bin Obaid was that 4 of the payments had the same basic purpose as the defendants had always said they had. We can see that if we look at Mr. Bin Obaid's 4th Wicks statement. That's in the supplementary bundle.
Can I just be clear before we just do anything else?
Yes.
The deleted payments they're listed helpfully in your skeleton, just right, page 100 and paragraph 7.1 table.
That's right, yeah.
And you've given some cross-references. What I'm not clear about is where the payments were made to and from.
Do you mean from which of the respondents to which of the...
Well, sorry, no, I meant geographically as much as anything else. I mean, are these payments made... They're not payments made in England, to accounts in England, from accounts in England, or are they? Do we know?
I would have to check that, I'm afraid, my lord. I wouldn't like to try and deal with that on my feet. My suspicion is that they may have come from accounts in Saudi Arabia, but which accounts they then went to, whether they came to accounts in England or not, I couldn't say at the moment. But we can certainly find out over.
But it's just, and it may go at this point may go nowhere, but it was triggered by something my lord said to you earlier. I mean, the essence of the claim, as subject to recital as well, is that it's to do with the ownership of properties and monies in accounts in the UK, isn't it?
Well, yes, certainly by the end of it. I mean, I'm sure it's. I just don't know off the top of my head, my lord, exactly how the funds flowed. I don't know how Dr. Al-Hezaimi transferred the funds to the English property developers, which were then.
But the deleted payments, by the time the settlement deed is put into effect, they're no longer part of the dispute in the UK. And I'm at the moment just wondering whether they actually have any connection to the UK at all. They're not. I mean, none of the parties are resident in the UK. They're not said to have resulted in property, or be connected in any factual way with property in the UK.
Well, perhaps I can come back to you.
So, as a matter of just, in a sense, what has that dispute got to do with England in relation to the deleted payments? The answer is probably not much, if anything.
That may be right. I will check whether any of the deleted payments came to account in the UK, if we have any evidence of that or not. It may be that they were entirely, as your lordship says, in Saudi Arabia.
And so the dispute, as a matter of pleading, the dispute about what they were for is completely out with both the pleading and possibly the jurisdiction of this court. Their only relevance is, as you said, to understanding the wider relationship evidentially, if that's part of the dispute, or because of the set-aside application.
That's right, my lord, yes. I mean, I will check and confirm, but it may well be that it would have been difficult to obtain permission to serve out a claim in relation to the deleted payments in England, for example, for the reasons that your lordship gives.
But don't worry, I mean, I don't want to put you on the spot.
Yes, I'm sorry, I don't immediately know the answer there. What I was going to show the court was the evidence of Mr. Bin Obeid that, in fact, some of the deleted payments were for purposes concerning the UIMP business. We can just look at that briefly. That's in the supplementary bundle. It's tab 12, page 291. That is the start of Mr. Bin Obeid's fourth witness statement. If you turn over to 292, what we have here is Annex 2 to his statement. And in this annex, Mr. Bin Obeid was identifying what payments he said were made by him for the purpose of the UIMP business. And in rows 9, 10, 11, and 12, that are on page 293, he identifies 4 payments. And all of those payments are deleted payments. And it's also worth noting while we're here that rows 9 and 10 are not only deleted payments, they are also, contrary to the evidence given here, payments to which claims are asserted in the 2019 Saudi proceedings on the basis that they are loans.
And row 12?
Rows 11 and 12 are deleted payments, but no claims so far asserted in Saudi Arabia in relation to them.
I thought the 6 million reals on 21st May 2015 was one of them. I may be wrong about that. Where's the easiest place to find the list of...
Oh yes, I'm sorry. Well, the easiest place, I have a list in my...
It is slightly confusing having all these different lists.
Yes, I'm sorry. Well, maybe the easiest place is actually attached to the judge's order. So that's in the core bundle.
Yep.
At tab 4, page 35. There's their Schedule 2, the Saudi 2019 Saudi proceedings, and that has a list of all of the claims there. So you can see row 6 in Schedule 2 corresponds to row 9, Mr. Binobade's statement, and row 7 in Schedule 2, 3 million, 5th of November 2014 date of payment, corresponds to row 10 in Mr. Binobade's statement. But rows 11 and 12 in his statement are not featured.
So is it not row 4? Number 12?
Oh, I'm so sorry. Yes, I'm so sorry. I missed that. I'm so sorry. You're quite right, my lord.
Anyway, it doesn't really matter because it's the principle that matters.
So just to tie a bow on reason number 1, we say that against the factual matrix, when one comes to ask, are claims to the deleted payments ones arising out of or in connection with the main action, we say the answer is yes. For the reasons that I've put to the court, they had formed an integral part of the main action. We had served evidence dealing with them in response. Claims had been removed, abandoned. Claims never had been reasserted, and in fact, in a number of instances, it had been accepted that the payments were for the purpose that we said they were. And so we say, look, in totality, against all of that background, that is reason 1 why the claims were settled.
Well, the fact that they've been accepted that they were for the UIMP business may give you a different defence in Saudi Arabia, which is that you can't blow hot and cold, or you've already admitted that they were paid for the business, so they can't have been a loan. Doesn't necessarily mean that they were settled, which is the question before us.
I accept it doesn't inevitably follow, my lord, but we would say it is relevant factual matrix, and if the matrix is, well, you have accepted that these payments are for the purpose for which we said they were, that is, we say, a reason why claims in relation to them have been released.
Well, that would draw a distinction between the 4 deleted payments which are dealt with in Mr. Binobade's 4th witness statement and the 11 which are not. That, I don't think, is part of your case, is it?
No, my lord, that's right. You're right, one could draw a distinction in that way. We say when one looks holistically at all the factual background, that is, we had served evidence challenging all of the payments, and they're removed, and one then reaches a stage where, in fact, Mr. Binobade's own evidence concurs in some respects on the deleted payments with ours. We say that in totality that's enough for us to get over the hurdle of showing that these are claims that should properly be treated as released.
Can I just be sure what your submission is on this reason 1? Is it because you originally pleaded these in the main action, therefore claims in relation to them are claims in connection with the main action, and it's irrelevant that you were no longer pursuing them at the time of settlement? In other words, claims in the English proceedings means claims that are now or have at any time been. It's a timing point. That's one submission. That's a rather different submission from the one which I think you're making, which is we said these deleted payments were nothing to do with the purchase of English property, that were instead to do with the UIMP business, and you then dropped them, which means you've abandoned them, and that means you can't now revive any claim in relation to them, which is a different point.
I think my submission is the second.
It's the second one. Yes. Thank you. That's very helpful.
Because we do pray and aid all of this. It's not just they were on the pleadings and they've now come off the pleadings and that suffices. We do rely on all of this factual matrix.
Yes, yes. Thank you very much.
Can I then turn to reason 2?
This is the set-aside.
This is the set-aside application, exactly. That's dealt with in paragraph 27 of the skeleton onwards. We make 3 high-level points. First, at the time the settlement deed was concluded, the set-aside application was in issue in the main action. Second, the true nature and purpose of the deleted payments formed a key part of the set-aside application. Third, that being so, we say claims to the deleted payments are ones arising out of or in connection with the main action.
Yep.
So taking each of those points in turn, first, there's no dispute that the set-aside application was an issue at the trial. That was specifically provided for in an order of Miss Amanda Tipple, QC, and just for the court's reference, that's supplementary bundle, tab 9, page 219, paragraph 1. The second point is that the true nature and purpose of the deleted payments formed a key part of the set-aside application. A central limb of the defendant's set-aside application was the contention that there had been material non-disclosure by the claimants when they applied without notice for the freezing order. And can I therefore begin by looking very briefly at some important aspects of the legal test which the set-aside application engaged, so that we can have them in mind when we look at the evidence and submissions connected with the application. The legal test was authoritatively summarised by Mrs. Justice Carr, she then was in Tugashev and Orlov, and that's at paragraph 7, which is in the authorities bundle at tab 4, page 8. Really, I just wanted to show the court 3. What is happening at paragraph 7 is that Mrs. Justice Carr was summarising the general principles that were relevant, and I just wanted to show the court 3. The first at 7.1, the duty of an applicant for without notice injunction is to make full and accurate disclosure of all material facts, and to draw the court's attention to significant factual, legal, and procedural aspects of the case. The second principle to highlight is at Roman numeral 4 at the bottom of the page. An applicant must make proper inquiries before making the application. He must investigate the cause of action asserted and the facts relied on before identifying and addressing any likely defences. The duty to disclose extends to matters of which the applicant would have been aware had reasonable inquiries been made. And then the final principle to quickly highlight is over the page, Roman numeral 10. Whether or not the non-disclosure was innocent is an important consideration, but not necessarily decisive. Immediate discharge without renewal is likely to be the court's starting point, at least when the failure is substantial or deliberate. It's been said on more than one occasion that it will only be in exceptional circumstances, in cases of deliberate non-disclosure or misrepresentation, that an order would not be discharged.
Yes.
So that was just the legal framework that I wanted us to have in mind. That's important because pausing there, the set-aside application was not merely about identifying whether the deleted payments were or were not for the purposes of the claimants acquiring property in England. It involved a broader inquiry which included identifying what the true nature and purpose of the deleted payments was, because that was relevant, first of all, to whether the claimants had made an innocent non-disclosure or whether there had been substantial or deliberate failure to make full and frank disclosure, and second, to whether the claimants had made proper inquiries before making their application. Can I now show the court the various pieces of evidence and submissions concerning the set-aside application, which we say are relevant to seeing how the deleted issues were in play? Can I start with Dr. Al-Hezaimi's first witness statement? That is in the supplementary bundle, tab 4. This witness statement was served by Dr. Al-Hezaimi in support of his set-aside application. And we can pick it up at paragraph 18, which which is on page 92. And we see above paragraph 18 the heading, the inadequacies of the claimant's presentation without notice hearing. And he says, despite these distractions, having been able to spend more time reviewing the claimant's case and the evidence provided in purported support of it at the without notice hearing, it has become ever clearer to me how impartial and misleading the claimant's presentation to the court was.
Presumably he means partial.
Yes. You're right, my lord. I think he must mean partial. Most strikingly, the claimants failed to make any adequate mention of, at 19.1, the UINP business, and then 19.4, the lack of correlation between the payments purportedly made for the acquisition of real estate and the actual payment amounts and dates for those purchases. And we can see how the point, and then just for completeness, to 21, he then says, for these reasons, I believe the order was procured from the court without notice hearing based on a partial, inaccurate, and materially misleading account of the underlying dispute. On account of these failings, at the without notice hearing, the defendants have applied to discharge the order. And we can see how the point that's mentioned in paragraph 19.4 is developed in his evidence. If we go on to paragraph 57, that appears on page 99 of the bundle, under the heading in bold, a little higher up the page, payments do not correspond to real estate investments. And paragraph 57, what it said is, the claimants refer in their particulars of claim to various payments, also set out in Schedule C to the order, and those are, in some cases, deleted payments, which they assert were paid for the purpose of investment in UK real estate on Mr. Bin Obeid Sr.'s behalf. In fact, that was not the purpose of any of the payments. Then over to paragraph 58. The vast majority of the payments were for the purposes of the UINP business, or subsequently to purchase my shareholding in UINP in 2015-2016. It was therefore entirely misleading for Mr. Bin Obeid Sr. to suggest that our joint ventures in Saudi Arabia and Egypt, the UINP businesses, were not directly relevant to the application, or that they were unrelated transactions. On the contrary, they were the very reason why the payments were made. So we see the defendants put in issue what the true purpose of the deleted payments was, and describe the failure of the claimants to mention the UINP business and its connection to these payments as entirely misleading. That evidence was laying the foundations for the defendants to submit that there had been a substantial and deliberate failure to make full and frank disclosure, or at least failure to make reasonable inquiries. The final piece of this statement to show the court is paragraph 66 to 67. And what it said there is, Mr. Bin Obeid Sr. also failed to inform the court without notice hearing that certain of the payments involved third parties and were for purposes which, again, and self-evidently, had nothing to do with UK real estate investment. In particular, as set out in the dependents, paragraph 67, the payment of 1.2 million made on the 8th of September 2014 corresponds to sums due to me in relation to a separate project I've been working on for the development of a tissue bank at Riyadh, the first tissue bank in the Middle East, in conjunction with a professional colleague with whom I've been working through my connections at King Saud University. Mr. Bin Obeid Sr. knew full well that was the purpose of the payment. The source of funds can clearly be seen from the bank statement exhibited to his own affidavit. His failure to identify the true purpose of this payment at the without notice hearing was again misleading. Given his knowledge of this purpose and of the origin of the funds, I can only assume that it was deliberate. Now this 1.2 million euro payment, this is a deleted payment. And again, we can see Dr. Al-Hezaimi expressly alleging that the court was deliberately misled about this payment. And so the evidence is not just focused on, well, what is the true purpose of this payment, but what was Mr. Bin Obeid's knowledge of that. The claimant's evidence in response on the set-aside application came in the form of the first witness statement of Mr. Bin Obeid, and that's in the supplementary bundle at tab 11. We can pick it up at page 241, paragraph 14, where Mr. Bin Obeid is dealing with the allegations of material non-disclosure. And in paragraph 14, Mr. Bin Obeid summarises the defendant's case, what they're saying the true purpose of the payment was. And he says that that case was entirely untrue. then over at paragraph 15, we can see a summary of paragraph 19 of Dr. Al-Hezaimi's statement that we just reviewed, and the allegations of material non-disclosure that the defendants were making. And then in paragraph 16, we get, in summary, Mr. Bin Obeid's response. So at paragraph 16a, he says, UIMP. Although Mr. Al-Hezaimi and I were both involved in UIMP, that company and all events relating to it are entirely unrelated to my agreement with Mr. Al-Hezaimi to fund the acquisition of properties in England in Onar's name, which is ultimately the subject matter of the proceedings. I understand from my solicitors that I was not obliged to set out extensive details about a matter that I genuinely and reasonably considered was completely unconnected with the proceedings. And then at paragraph 16d, we have him dealing in summary with the correlation of payments. And what he said was, I did in fact draw the court's express attention without notice hearings to the fact that due to my various other dealings with Mr. Al-Hezaimi at the relevant time, I was in certain cases unable to expressly identify which payments were made for which purposes. It was therefore unavoidable that the correlation between payments I made to Mr. Al-Hezaimi and payments that were made to acquire the properties would in some cases not be certain at the time of the without notice application. However, the claimants used their best efforts at the time, given the urgent need to apply for injunctive relief against the defendants. So just pausing there, we see Mr. Bin Obeid engaging with whether reasonable inquiries had been made and whether the non-disclosure was intentional. And his position was, no, best efforts were made to be accurate. And we can see that if we carry on with paragraph 16d, he continues, I've now had further time to review my financial records and also now have the benefit of disclosure from various third parties under the disclosure order. As a result of this, I've been able to establish a very clear correlation between the payments I made to Mr. Al-Hezaimi and the payments made to acquire the properties. While the claimants apologised to the court for not being in a position to present such a complete picture at the time of the without notice applications, I believe this was reasonable in the circumstances and was not a material non-disclosure such as to justify the discharge of the freezing. So again, we see Mr. Bin Obeid emphasising that what was said at the without notice stage was reasonable in the circumstances. And finally, if we just turn on to page 282.
This is a witness statement which was made for the purpose of the return date.
That's right.
And that's prior to the deletion of the deleted payments.
Yes, I think that's right, my lord. I think chronologically it may be that this this statement was served, if not on precisely the same date, either very shortly before or after the amended particulars of claim. So,
well, the amended particulars of claim are not served until the 23rd of October, and this is dated the 8th of October, I think, 6th of October. But he does say in it that he intends to apply for permission to amend. So he may have sent you a draft at around the same time.
Yes, I think that's right. But it was at this stage being recognised that certain of the deleted payments were not now payments that claimants.
Yeah, now it's just, he says he's been able to establish a very clear correlation between the payments I made and the payments made to acquire the English properties. He's not, there's no carve out there. I'm just trying to get, there's nothing significant in this other than trying to get the chronology clear in my own head.
Yes.
This sort of suggests it's before he's...
But I think what he's saying is that, I think what he's saying is, at least in general terms, he's now got a correlation between the payments that claims are still going to be asserted in relation to and the completion dates of the property. He's now happy with that, having been through the further disclosure. But I don't think he's suggesting there is obviously a correlation for the deleted payments.
Right, he deals with it at page 264, and at 109 he refers again to having carried out further investigations, and at 110 he says the claimant's understanding has developed since the without notice applications, and at 111 he says he intends to seek permission to file an amended particulars claim in due course. So I think you can say that there's a recognition in that some of the payments may no longer be relied on.
Yes.
But I don't think he says that in terms but he does go on and provide quite a lot more chapter and verse for the payments that he is going to rely on.
That's right. Although I don't suggest that is.
Oh, actually, go to page 279, paragraph 182. Here's a revised table, my current understanding as to the payments. So I think that does accept that anything not there wasn't made for the purpose of investment acquisition of English properties.
These are all sterling payments, as opposed to all the deleted payments, which are South African rands, aren't they?
Yes, I think what he's summarising here are these are the payments that were made to acquire the English properties. And that's why they're all in pounds, because they're being paid to English.
Oh, so it's not payments by him, it's payments...
No, these are payments that were made to acquire the properties, because I think that the point that was being made was you are asserting that you paid us a certain amount X for property Y. Well, in fact, you paid us amount X after we had already paid for property Y, so there's no correlation there. So it can't be that payment X was for property Y. In fact, payment X was for the UIMP business, and there was a material failure to explain to the court this wider business relationship. And had you done that, these sorts of points would become apparent. And so what my understanding is Mr. Binove is dealing with in this section is explaining, oh no, this is how the correlation works. So we don't in a sense engage with any of that for the purposes of our deal here. Really what I'm showing your lordships this statement for is to show that Mr. Binove was joining issue with the evidence that Dr. Al-Hezaimi gave that there had been some deliberate misleading of the court in relation to the deleted payments, because as we've seen, for example, in paragraph 16, he was saying no reasonable efforts have in effect been made. And the final bit of the statement that I wanted to show the court is in relation to the tissue bank payment. That's on page 282, paragraph 189 to 191. Could I just ask the court to read those paragraphs?
Lords, before the court does that, can I just interpose a matter of clarification? The Lord Justice Snowden said South African rand, it's Saudi real. There's the Saudi Arabian real.
Okay. I don't know why South Africa's come into my head. Sorry. That's completely...
And the other thing is that although Mr. Binove says in his identifies the payments in his witness statement as being in pounds sterling, in fact, in the pleading, they were made in Saudi real, and these are conversion rates.
So these, on page 280, this list of 15 apparent sterling payments are payments by him or the third claimant, which are relied on in the amended particulars of claim.
The Lord, those are the 15 payments which are listed in the amended particulars of claim. And as your Lordship would see from supplemental tab 5, when they find their way into the various tables which are given there for in relation to each set of properties, they are properly identified as having been made in Saudi Arabian riyal and then converted into sterling. Lord, for example, in tab 5, page 118, the City Tower development, paragraph 19 of that, your Lordship can see the amounts are stated in Saudi real. Tables are paragraphs 19, 31 and 40, and that's in the original pleading. We've got them in compendious tables elsewhere, but that was in the amended particulars of claim. The payments were made in Saudi Arabian currency.
Yes. Thank you.
Lord, I apologise for interrupting the learned from Mr. Ho, but I didn't want the court to go off on a false premise, as it were, that there was some distinction to be made between the currency and the payments.
Thank you. Yes.
Yes. So coming back to paragraph 189 to 191 of this witness statement, that's on page 282. Those are the paragraphs that I was inviting the court to read. That is Mr. Binebey's response on the tissue bank deleted payment.
Yes.
And we can see that he absolutely rejects the assertion that he's deliberately misled the court in relation to that payment. And so from that evidence, we see that the battle lines that were being drawn were not just about what the purpose of the deleted payments was, but first, whether the claimants had made best efforts to be accurate at the without notice stage, and second, whether their failure to identify the relevant payments and to have relied on the deleted payments was reasonable in the circumstances. And in particular, so far as the tissue bank payment was concerned, we see Mr. Binebey clearly denying that he deliberately misled the court about that payment.
Yeah.
So we say the evidence served for the set-aside application was therefore not just Mr. Binebey saying, well, we accept that the deleted payments aren't properties in England, and that being the end of the matter. His evidence went further. It concerned, well, what did the claimants think the deleted payments were for, and why was it reasonable for them to have supposed that they were to do with the English properties, and what was the true nature of those payments. And all of that evidence was relevant because it would illuminate whether there had been, for example, a deliberate non-disclosure. And just to give the references, Dr. Al-Hezaimi then served his second witness statement in reply. That's in the supplemental bundle, tab 6, page 134. And could I just, in due course, ask the court to look at paragraphs 9, 9.1 and 11 of that statement. There you will see Dr. Al-Hezaimi effectively joining issue with Mr. Binebey about what he must have known or what he ought reasonably to have known about the true nature of the deleted payment. Now the deleted payments, the set-aside application was originally due to be heard at a hearing in December 2017. As we know, that was ultimately adjourned to the trial. Can I just quickly show the court, though, the defendant's skeleton for the hearing that was going to take place in December 2017? The reason for showing you that is because that identifies the issues which we say were live on the discharge application, and we were relying on that as a reason why it should be, the discharge application should be adjourned to the trial. We can see that in the supplementary bundle, tab 8. Page 198, that's the skeleton. And if we turn on in that page 204, there is a heading there, D3, the issues to which the discharge application gives rise, overlap with those at trial. Paragraph 25, it says the grounds upon which the discharge application was made are set out in the first witness statement of Mr. Al-Hezaimi, paragraphs 18 to 21, and we've looked at that. There are two broad complaints. The first is that the claimants obtained the Barling J order, which is the freezing order, on the basis that they had a good arguable case for relief in respect of the specific payment detailed in the particular claim, said to have been for the specific purpose of acquiring particular UK properties. That statement of the case was verified by a statement of truth. However, as the defendants pointed out in their evidence in support of the discharge application and by the defence that they served at the same time, the pleaded case was unsustainable. Claimants have now conceded as much by the wide-ranging amendments that they subsequently made by the amended particulars of the claim and the abandonment of the claimant's case in respect of various of the payments upon which they had originally relied. To some extent, these issues are discrete from those arising at trial. That's because they concern the circumstances in which the particulars of claim were filed in the form that they were, given the evident lack of basis for the case advanced. However, the trial judge will be best placed to deal with these issues once all the relevant evidence has been heard. So, what the defendants were contending was the freezing order application relied on the particulars of claim. The particulars of claim contained unsustainable allegations, and the issue for the court was how could the particulars of claim have come to be filed with the deleted payments in it, given that those payments were ultimately accepted to have nothing to do with buying English property. That argument was important to our material non-disclosure case, because if, for example, it was shown that the claimants knew that the particulars of claim was inaccurate, that would vindicate an argument that there had not been full and frank disclosure, and that, as we've seen from the evidence served by the defendants on the set-aside application, was precisely our case. The last...
Just in paragraph 29,
yes?
You just right, it said that the matters to which the second issue gives rise are intimately bound up with the case to be tried, and then you describe the true purposes which the payments are made being. So I'm struggling just to find the second issue.
Yes, the second is paragraph 28, my lord. The second broad matter of which we complain is that no mention was made without notice hearing of the UINP business, the agreements between the parties.
That is that.
It's that.
So it's, yeah, okay. So, you draw them. Okay.
The final, just to sort of close the archaeological dig on the main, on the set-aside application, the final thing that I wanted to show what was just some of the cross-examination that Mr. Bin obeyed at the trial. It was very shortly before the settlement deed was executed, showing that he was being asked about issues related to the set-aside application.
And is this right, that the witness statements for trial stuck to the pleaded issues, if I could call it that, for trial?
I believe that.
Or, but,
yes.
I mean, we have them somewhere, but you haven't taken this to them.
Yes, I believe that's right. There wasn't, in the trial witness statements, I don't think, there wasn't anything that was elaborated on in relation to the deleted payments in those, I don't believe. I believe they were concentrated on evidence to do with the actual payments that were in dispute. Although, as we'll see when we come on to reason 3, we were of course saying that the wider picture, including the evidence from the set-aside application, was relevant to understanding that evidence. Yeah,
no, I was just wondering, given what said in paragraph 29 about the fact that they would be intimately bound up, I just wondered whether the witness statements for trial
yes.
Actually went over those points, or whether they were sort of separate, but these ones were relied upon at trial as well.
I believe that was the position, that latter.
Okay.
So yes, the final thing to show you is just the cross-examination of Mr. Bin Obeid. In cross-examination, Mr. Bin Obeid was asked about deleted payment number 5, that is the tissue bank payment, which we've seen on a number of other occasions. We can see the cross-examination at tab 16 of the supplementary bundle. If we go to page 327, numbering of the bundle. Now, the cross-examination was quite slow going, so I just wanted to show you two parts of it. If we start on internal page 31, line 15, you can see that Mr. Anderson, who was King's Counsel, who was my client, said, now, just before we had a short break, Mr. Bin Obeid, I was asking you about a payment of 1.2 million euros that you were claiming Dr. Al-Hezaimi owes to you. This is, can you confirm your bank statement, one of your bank statements, it has your name on it. And if the court would just read down to the end of page 32. We can see what was happening on 32 was Mr. Anderson was putting the bank statement to Mr. Obeid in order to establish how deleted payment 5 came to be transferred from Mr. Bin Obeid to Dr. Al-Hezaimi. And then over on 33, he starts putting an email exchange about deleted payment 5 to Mr. Bin Obeid. I don't propose that we look at the detail of all of that, but I just wanted to show the court this passage as an example of the defendants investigating a deleted payment with Mr. Bin Obeid and the sort of evidence they were putting to him about it. The second part of the cross-examination that I wanted to show the court is over on page 330. It's effectively the culmination of this line of cross-examination, and we can pick it up on internal page 42, line 20. Mr. Anderson says, listen carefully to the question. The question is confined to, this payment relates to bone tissue. It does not relate to UK real estate. Agreed? And the answer is, what is coming from Barack is related to the bone tissue. Thank you. So we can see Mr. Anderson is establishing with Mr. Binabed the true nature and purpose of this deleted payment. And then over onto 43 and 44, could I just ask the court to read those two pages of the transcript?
Sorry, what do you want us to read?
Internal pages 43 and 44, please.
To the bottom of 44.
Yes, please.
Thank you.
What we say...
I can't quite see how you can ask the question, did you tell them X without trespassing into privilege, but it doesn't really matter now.
Well, what we say we can see being done here is that having established the true purpose of deleted payment number 5, Mr. Anderson went on to ask questions designed to understand how the claim in respect of it in the original particular claim had come about. That was a clear pursuit in cross-examination of questions relevant to the set-aside application.
Yes.
And there was no objection from anyone in court, particularly the judge, that this line of question wasn't relevant to anything that was in dispute. So, my Lord, I apologise for that rather lengthy archaeological dig through the main action, but I hope that shows why we say the set-aside application was an issue at the trial. The set-aside application involved an investigation into the true nature and purpose of the deleted payments. And that investigation was one that was actually ongoing at the trial very shortly before the second plea was executed.
I mean, just putting it bluntly, obviously, I mean, you're saying this is all matrix to the interpretation of the agreement.
That's right. We say when one comes back to the proper interpretation of the settlement deed, we say that on the ordinary and natural meaning of the words in that, claims in respect of the deleted payments are claims arising out of or in connection with the main action. That's because the main action included, as part of the set-aside application, an involved and detailed debate about the true nature and purpose of the deleted payments. Now, I'm conscious of the time. I'm trespassing, I'm afraid, into time that I had agreed would be...
You shouldn't rely on that clock, because it hasn't moved for the last hour and a half.
Yes, that would be wonderful if we could...
but it is actually, by coincidence, almost right at the moment. How much longer do you want to be?
I think if I could have another 15 minutes, that would be very kind.
Does that put you in any difficulties, Mr. Smith?
No, my lord, it doesn't.
No. Yes, we'll carry on.
Thank you. So can I then, in that case, just move to quickly dealing with reason number 3? The third distinct reason why we say claims in respect of the deleted payments arise out of or in connection with the issues in dispute in the main action. That's paragraph 33 onwards of our skeleton. In short, we say that independently of the set-aside application, the true nature and purpose of the deleted payments were an issue at the trial. First, as part of determining what the purpose of the payments in respect of which claims were asserted in the amended particular claim were, and second, as part of assessing the general credibility of the witnesses. The defendant's position before the judge was that the purpose for which the payments, in respect of which claims were asserted in the amended particular claim, couldn't be determined in a vacuum. Those payments had to be seen against both the backdrop of the parties' wider business relationship, especially UIMP, and, since the documentary picture was so confused, against the backdrop of the general credibility of Dr. Al-Hezaimi, Mr. Binabed. The court is, I think from something that my lord put to me earlier, aware that in the main action pleadings, there had been pleadings about what the purpose of the deleted payments were. Just to give you the reference, we pleaded in the amended defence at supplementary bundle, tab 7, page 155, paragraph 25, what we said the purpose of all but one of the deleted payments was. We said they were for the purpose of the UIMP business. And at paragraph 31 of the amended defence, page 158, we pleaded the purpose of the Tishy Bank project payment, the one that we looked at cross-examination, and we said was for the Tishy Bank.
Yes. I mean, I saw that you pleaded that. But let's look at paragraph 31 as an example. What you've done is you pleaded this originally in your original defence, for perfectly understandable reasons, because in the original particulars of claim, the 1.2 million was being sued on. But as the amendment acknowledges on page 158, the claimants have abandoned their claim in respect to this payment. So why is paragraph 31 still in your pleading? What issue for trial does it go to? I can see it goes to a question of set-aside, you've done that, but you're not pleading in relation to the set-aside, you're pleading in relation to the claims.
Well,
it's a general principle that pleading should only state material facts, and material facts are only those which are material to the causes of action sued on. And I don't see how this has any relevance to any of the issues sued on. I may be missing something obvious, but at the moment, I can't see why you've left it on the pleading. Oh, and the same with 25. I can't see why you've left that on the pleading, apart from the three which are highlighted, four highlighted.
Yes, well, we say that was left there because that those while claims weren't asserted to those payments anymore, they were relevant as part of determining what the purpose of the payments in respect of which claims were asserted.
Did you ever file an amended defence?
This is our amended.
Sorry.
This is the amendment.
This is our
The red bits. So page 155 of the supplementary bundle.
Sorry, I'm looking at the wrong. Sorry, I'm looking at the wrong document. Sorry.
Well, I know that people often put all sorts of things in pleadings which they shouldn't. My understanding of the principles and the rules is that pleading should only state facts material to the causes of action sued on. Although you can also plead law these days. You shouldn't plead facts which are merely background or narrative or might help you to persuade the judge your answer to the causes of action sued on is correct. I mean, I think this is at the moment, I don't see what these paragraphs are still doing in the pleading at all. And that's not to dispute your position that an investigation of the commercial relationships generally between the parties was something you were going to explore at trial because it would shed light on why the payments which were sued on were made. I still don't see why it should have been pleaded. But anyway, there we are. It was pleaded.
Yes, but as you say, it may be that the answer is historic, that they were there originally because those were the original claims. We relied on them for this wider purpose. Quite possibly they shouldn't have been pleaded for that wider purpose, but they were there on the pleadings anyway.
But it's not your pleading.
No,
It's not your pleading. No. It's not a criticism.
But I'm defending those who
Yes.
whose pleading it was. But it may be for that reason that it was on there. But I do say this is the fact that it's on the pleading still does add support to the submissions I'm going to make. This was an important issue in the case. It's not just some peripheral thing that we've alighted on that somebody was arguing about in some marginal way, and I'm therefore saying to the court, well, it was an issue in dispute and therefore covered by the settlement agreement. We say it's much more important than that. So, can I show you then Mr. Anderson's oral submissions at the trial? Those are in the supplementary bundle at tab 15.
This is the opening, isn't it?
The oral opening, that's right.
Yeah.
And we can pick it up on page 324 of the bundle. It's internal page 61, line 5. And could I just ask the court to read from line 5 to line 21 on page 62, please?
Yes.
So just summarising those submissions, Mr. Anderson identified the issue for the court was the purpose for which the payments in the amended particulars of claim, that's the 35 million that's referred to in line 13 on page 61, were for. He says that in tackling that issue and considering the evidence, 5 general points need to be kept in mind. We emphasise the second of those, which is dealt with in lines 10 to 21 on page 62. In particular, at the end, in lines 20 to 21, Mr. Anderson specifically identified that the claimant's change of position would be focused on in the evidence. So plainly, we say the defendants were going to be asking for findings in relation to that. And so right at the outset of his submissions, Mr. Anderson was identifying how important this change of case was when assessing the evidence more generally. We then move on in his oral submissions. We can pick it up at page 66, internal page 66, line 9. Mr. Anderson said, "We also set out in our written opening a number of themes we invite my lady to bear in mind when assessing Mr. Binobey's evidence, and have in mind when he's giving his evidence. They're essentially, principally, fourfold. First of all, his lack of candour regarding UIMP, particularly at the without notice stage. Secondly, his continuing lack of candour regarding his relationship with Dr. Al-Hezaimi, which we say is central to the issues in this case. Third, the false account he initially provided regarding the purpose for which payments were made. Again, we will explore that in the evidence. And fourthly," and then the judge interrupted, "your reference to the false account, you were referring again to the payments that are in the original pleaded state of the case." And this is me now saying that is the deleted payment. And Mr. Anderson then said, "Yes, and in the original affidavit, the original sworn evidence on the without notice application. Mindful, no doubt, they tell us in terms, mindful of their duty of full and frank disclosure, yes. My lady, fourth, the unsatisfactory, we say, incredible account that has been given of the UIMP share sale, particularly having regard to the framework agreement and many other contemporaneous documents, only some of which you will have seen so far. I do not propose to say anything more about that now because we will need to return to these themes in closing once the evidence has been heard and tested."
Well, that all goes to credibility, doesn't it?
It does, my lord, yes, I accept that, but those themes that Mr. Anderson are relying on were front and centre of the submissions that he was making relevant to the claims that were actually being asserted, because what was being said was it's so difficult to unpick this evidential mess because it's a largely oral relationship, very few formal documents. One is going to have regard to these sort of points because it is, at the end of the day, going to come down to the credibility of the witnesses. And so what went on with the deleted payments is an important aspect of that.
See, I mean, you just say the purposes for which the deleted payments were made was still an issue in the English proceedings.
That's right.
Not a pleaded issue in the sense of one that the court would need to resolve, but it was an issue which the court would need to resolve for the purpose of the set-aside and credibility on the other issues which were directly in issue. That's right.
Yes. And if necessary, I would say it was an important issue because I recognise the point. I can't. It's highly unlikely that the settlement deed means that any issue, however peripheral, that was in dispute in the main action, any claims in relation to that.
Yeah, you pick up my lord's point that not every issue going to credibility would be caught by this deed, but you say one which is centrally relevant to credibility in this way.
Yes. And can I just show the court one final thing in relation to the submissions we were making in the main action? That is just to elaborate a little bit more the third theme which Mr. Anderson had referred to orally that we've just looked at. That's developed in the skeleton, the defendant's skeleton for trial, which is at tab 14. And if we go in that to paragraph 62, which is at page 314. Sorry, 315. I'm so sorry. Paragraph 62 on 315. There's a heading at the bottom of the page. Mr. Binobey's false account of the purposes for which payments were made. Could I just ask the court to read paragraph 62 to 64, please?
Yes.
Yes. So in a sense, it doesn't take any further than the oral submissions I've shown you, but it does just re-emphasise the basic point that I've been making. That we were saying this was what happened with the deleted payments was an important issue that was going to need to be investigated. And so I then take my the summary that Justice Snowden put to me. That is why we say that even independently of the set-aside application, the deleted payments were in issue in trial at the trial of the main action. Therefore, because they were issues that were disputed, they fall within the definition of claims. Can I just, in the last few moments that I have, deal with the respondent's interpretation of the settlement deed? I just want to deal with one point, which is the point that Lord Justice Snowden asked me about earlier, which is what is the significance of the second sentence in the definition of claims, the for the avoidance of doubt wording that's in the definition of claims. We can see that in the back in the core bundle, tab 10, page 129. The second sentence, for the avoidance of doubt, this clause shall not prevent the parties from pursuing the litigation in other jurisdictions. Can I just explain what we say about that? We say that doesn't point against our interpretation. The first sentence of the definition of claims is the governing operative sentence, which in effect defines the scope of the release. It releases two broad categories of things. First, any claims arising out of or in connection with the main action. Second, any claims arising out of or in connection with any claims for rental payments or other proceeds of the identified assets. The second sentence provides a carve-out from that release. It identifies when other litigation currently in progress, which would otherwise fall within the scope of the release, can continue. The general rule it provides is that ongoing foreign litigation can continue. So even if foreign litigation involves, for example, a claim connected with the issues in dispute in the main action, that claim can continue, contrary to the effect of the release otherwise provided for in the first sentence. However, that general rule is subject to a limitation. Foreign proceedings which involve, number one, an overlap, and number two, with the claims in the English proceedings, are settled. It's important to focus on the language used in that limitation. To decide whether foreign litigation which is on foot is settled, we do not apply the general test in the first sentence of the definition of claim and ask the broad question, do the claims in the foreign litigation arise out of or are they connected with the English proceedings? Instead, we ask a much narrower question. We ask first, not do the claims arise out of or in connection with the English proceedings, but do they overlap, i.e. are they the same as? And second, we are not focused on the English proceedings generally, but instead on the claims in the English proceedings. So we apply a much narrower test. We have to determine whether claims in the foreign proceedings overlap with the claims that were in the main action. And that, we say, is very different, a very different question from the one that's posed in the first sentence, and there's a good reason for that. Since this part of the clause potentially has the effect of releasing ongoing claims in Saudi Arabia, certainty, clarity, and ease of application were paramount. Limiting the release to Saudi claims which overlap with the specific claims in the main action provided that. And in particular, it avoided the need for a potentially involved and difficult argument about whether an ongoing Saudi claim to do with UIMP, for example, was a claim in connection with the main action, given the issues it involved. So drawing the threads together, the second sentence is a carve-out of the operative release in the first sentence.
In which case, saying for the avoidance of doubt is misleading. It's not for the avoidance of doubt, it's but this clause.
Yes, well, we say that the words for the avoidance of doubt, really what they do is they serve to emphasise and formally record what the parties well understood. This settlement was not a general release of all litigation between them. And whatever the words in the first sentence, foreign claims are not to be released, except where they overlap with the claims in the main action. But we do say that there is very different language used in the second sentence, and so we say it doesn't. It has the purpose and effect that I've explained. It doesn't tell one the way the first sentence is limited.
Do you accept that the words for the avoidance of doubt are frequently used by people in agreements? Usually they just end up in a dispute. Because, I mean, if it was genuinely for the avoidance of doubt, you probably shouldn't say it anyway.
Yes, what I say, my lord, is I don't think that you should attach too much weight to those words.
Yeah, okay.
It's more important to look at the rest of the words that follow. We say they have a different language, different purpose, and one shouldn't put the cart before the horse.
Thank you.
And so, unless I can assist the court further, and I apologise again for trespassing on my learned friend's time, those were my suggestions.
Well, can I just be sure?
Yes.
I think you were clear about this. We go to your skeleton.
Yes.
At page 187 of the core bundle.
Yes.
I've put a line through paragraphs 35 and 36. That's correct?
Thank you, my lord. Yes.
Yes. And in terms of the relief, can we just look at the relief you're seeking?
Yes.
Where do we find that?
That will be in our appellant notice.
Page 6.
So that will be, page 6, behind tab 1, in box 9, or section 9. So we are asking you to...
So it's all the deleted payments.
Yes. The concessions that we have made don't actually affect the...
They don't, because the August 2013 one wasn't a deleted payment.
That's right. We were never asking for a declaration in relation to that. Well, what we were saying, in effect, was my learned friends can't have their declaration.
I see.
But we weren't asking for anything positive.
Do you want to say anything separate about the one which was omitted by mistake? There seems to have been a dispute whether the mistake was it should have been deleted but wasn't struck through, or it should have been left in but wasn't left in.
Yes, well, the relevance of that dispute was because it's not actually in the bundle, but Mr. Anderson then cross-examined, for example, about that further deleted payment. And we were saying...
Well, it wasn't a deleted payment because it wasn't there. It wasn't struck through, it was omitted.
But the omitted payment, the January 2015 payment. We said that is an example of a further deleted payment. We accept that it wasn't struck through, but it was removed from the claim. And so...
Does it make any difference on your case?
It's not, no, my lord, it's not central. I was just explaining the reason for it was because there was cross-examination about it. We, at trial, relied on that cross-examination in much the same way we relied on the cross-examination relating to deleted payment number 5. And said, oh, well, look, here's another example of what is technically a deleted payment being asked about. And the reason for that is because it's relevant to reason 3, the general context of the parties' relationship. My learned friends, I think, said, well, this payment actually hadn't properly been deleted, and so that the cross-examination of that doesn't actually assist me, because it was still an issue in the trial. I don't think it's really something that we need to resolve. I've shown the court, as it were, the high points of our evidence on the set-aside application and on the relevance of the deleted payments to the wider inquiry. I suspect the court will either be with me on that or not. If you're not with me on the high points, be persuading you that the
I'm more interested in terms of relief that you're seeking.
Yes.
Because the relief you're seeking is limited to the deleted payments. This one, I think the omitted payment is not technically a deleted payment as defined, but logically on your case, it doesn't matter whether it was omitted and should have been included or omitted and should have been deleted, because on either view, it's been settled. Is that right?
I'm so sorry, my lord. Yes. Yes.
So you do actually, you would actually like a declaration, but it's gone as well.
Oh, I see. It's pointed out to me, my lord, I have forgotten that at trial in these proceedings, you will know there was a case on rectification, and the solicitors on both sides served witness statements. The solicitor acting for Baker and Mackenzie, one of them, Mr. Secunda, had said in his witness statement at paragraph 24, for the purposes of these proceedings, which relate to the scope of the claims released under the settlement agreement, the claimants accept that their claim in relation to the missing payment has been released, despite the accidental removal from the main action.
Okay.
That's paragraph 24 of this statement.
Yeah. Thank you.
Thank you.
Yes. Do you want to make a start?
Well, just on that, if I could invite the court's attention to Core Bundle tab 8. And within tab 8 to page 88. The court will see that we there define the Saudi proceedings. And the first of those is in relation to the 28th of August 2013 payment.
Yes.
And paragraph 18.1, we say was not referred to in the original particulars of the claim or the amended particulars of the claim.
Well, as I understood it, the August 2013 payment is not being pursued.
Well, my Lord, that's not my understanding. If the court looks at page 99 in that, and paragraph 1, the court will see that we prayed for declaratory relief identified in paragraph 22 above. Paragraph 22 is back on page 90. In view of the defence's asserted the claimant seek a declaration on the proper construction, it didn't compromise, relate or waive any claim in respect of the deleted payments or the August 2013 payment.
Yes, but as I understood Mr. Hove, from what he said this morning, he is not disputing that the August 2013 payment has not been released.
Lord, I'm grateful. But that, my Lord, was one of the matters in relation to which we obtained a declaration, which I was about to show the court, from the learned deputy judge.
Is the point this, that even if he's right, he can have his declaration as to deleted payments, but it leaves unaffected the declaration as to the August 2013 payment?
Your Lordship has it. Exactly.
Well, I don't imagine that's going to be in dispute.
Lord, I only mention it because it was a convenient
Yes.
segue, as it were, to the points that we've just been making.
Well, no, the point I was on was a slightly different one, which was the omitted payment, which is the one which was originally pleaded and didn't appear either in deleted form or in any other form in the amended particulars of claim, which was said to have been an inadvertent mistake. But there was a dispute as to what the mistake was.
Lord, indeed.
And what he's told me, unless you tell me otherwise, I will proceed on this basis, is that for the purposes of these proceedings, you have accepted that that has been released.
Lord, yes.
Yes, right. So there's no dispute about that one either.
Thank you. Lord, I'm simply clearing the decks.
Yes, no, very helpful, very helpful.
That's a useful thing to start with. I wonder if I could trespass on the court for 5 minutes, perhaps after 1 o'clock, because that would be a convenient exordium, as it were, to my submissions. Because otherwise I've only got 4 minutes, as it were, and it's difficult to say anything useful in 4 minutes.
Well, let's draw stumps now then, and resume at 5 to 2, and you can have your exordium uninterrupted.
I'm extremely grateful.
Yes. 5 to 2.